To the debate, which is on the Financial Services Authority and the Connaught Income Fund, as soon as everybody's ready to start. Mr. Alan Cairns.
Thank you, Mr. Brady. It's a pleasure to serve under your chairmanship for the second time today. But I should also use this opportunity to welcome the Minister to her role and welcome her involvement in this important issue. As you can see, Mr. Brady, this debate has drawn much attention from colleagues and investors alike. Naturally, investors want explanations of what went wrong and why. Colleagues that have looked into the case recognise the scale of wrongdoing and want to know how it happened and any recourse their constituents may have. This is an issue that has developed for some time, but I think it's the first time that we've had the opportunity to raise concerns on the issue and to ask questions on the record. The Connaught Fund was launched in April 2008. It was promoted and operated by Capita Financial Managers Limited, who are also the custodian of investors' assets. Its original name was, interestingly, the Guaranteed Low Risk Income Fund Series 1. Something that proved not to be the case. It was a UK-based, unregulated corrective investment scheme, and by definition, these funds are not subject to direct regulation. However, elements of the process and funds were regulated, which means that, the regulatory framework and responsibilities are not necessarily straightforward and complex, but there is a responsibility towards the FSA. I will give way.
Congratulate him on securing this very important debate. Both he and I have fought Capita for over 3 years as part of the Arch Crew disaster, where similar losses were entailed, and I certainly have several constituents who've lost money through Connaught. Does he agree with me that it is appropriate to invite the Minister to seek the police's involvement and see whether an appropriate investigation should take place?
Well, I'm grateful to my honourable friend and pay tribute for his work over Arch Crew as Secretary of the All-Party Group and the involvement with Capita. And I think he raises some pertinent points which I will come on to in a moment. So I'm grateful for his contribution.
So early, and I have to leave because I've been in a debate hour and a half with him, and I congratulate him. Is he as concerned as I am of the little information that is available on Capita, particularly the signing off of the information memorandum? And that is causing great concern to a number of my constituencies, I'm sure many members' constituents across the House.
Well, I'm grateful to the honourable member for Ynys and he raises extremely important points about Capita that I will come on to, but particularly what knowledge they had at various stages, I think, is a central factor. I'll give way to the honourable member.
That's right.
On the issue of Capita, is this the same Capita that has won the personal independence payments contract with the government for Wales and the west of England?
Okay.
I'm grateful to the honourable member for the Vale Clwyd for his contribution, but of course Capital Financial Management is different to some of the other subsidiaries of Capita, but the parent company will be the same, and there are several subsidiaries, but I think the point has been well made, and I accept it in the way it was intended. Mr. Brady, I'd like to pursue the matter just a little bit further before accepting any other interventions to offer a form of background. And the proposition was that investors' money would be loaned to borrowers requiring short-term residential bridging loans. Loans would not exceed modest loan-to-value guidelines. No subprime lenders or properties would be financed. All loans would be secured by a first charge against those properties. Specifically, there was to be an average loan-to-value rate of 56%. They were told seldom above 70%, and anything above 80% would have guaranteed exits. All interests and fees would be taken up front, and there was a guarantee from Toyota, a company I will come on to shortly, to meet any shortfalls. The borrowers would pay an interest rate of 17.9%, while investors would receive quarterly distributions of between 8.15% and 8.5%. So Capita, who've already been referred to, appointed Toyota plc and Connaught Asset Management Limited, both UK companies, to identify suitable borrowers to approve the loans. Investors' funds were used differently, however. Money was transferred to Toyota rather than being released directly to the borrower solicitors. It is even suggested that there was no differentiation between the firm's own funds and that of the investors. This includes using investors' money to meet working capital needs of Toyota, paying directors' salaries and bonuses, and their pension contributions. In many cases, where bridging loans were made, the type of borrowers, properties, or loan-to-value ratios were not as committed in the promotional literature. It's believed that Toyota proposed loans, drew down the money, but did not proceed with the lending. It suggested that Connaught provided a monthly statement to Toyota's management accountant, switching the true loan book and that of the approved one. In March 2009, Capita became aware that the original information memorandum was misleading. The fund should not have been described as low risk, the guarantee from Toyota was of no value, the money was used largely for purposes other than bridging loans, and the auditors of the fund were not engaged. In addition, the loans that had been made were not as described and were being rolled over. In 2009, Mr. Brady, after Capita met with Connaught's senior management, investors were informed by Capita that they were resigning as operator of the fund. They were to be replaced by Morant Fund Services Limited, but for some unknown reason, Morant did not complete the transaction, perhaps because they became aware of the problems with the fund. I will give way to my honourable friend.
To my friend for giving way, and I congratulate him on securing this debate. Isn't it a significant concern to all of us who have been looking at this issue that in 2009 it became apparent that Capita did have significant concerns about the way in which the fund was being operated, but those concerns were not conveyed to those who had invested in the fund?
Okay.
Well, I pay tribute to my honourable friend for his work in support of investigating this matter, and he raises an extremely important point. There's a serious question of what did Capita know and what didn't they know, and what should they have communicated to the investors who they were who they had a responsibility towards. I'll give way to my honourable friend.
Bill
I'm most grateful to my honourable friend for giving way, and I draw the House's attention to my register of members' interests. My constituent, Mr Sudworth, who is a victim of this fraud as well, has raised a question with me, and I wonder if he knows the answer. Is it the case that the FCA outsourced some of its work to Capita?
Well, I'm grateful to my honourable friend for asking that point. I don't have the answer, but I think he points to a general defensive approach that has been taken by the FSA and the FCA. We're seeking greater transparency to answer many of these questions so that we can identify where the responsibility lies. So perhaps Morant came aware of some of the issues that have now transpired to come true. But instead, Capita passed on the responsibility to Bluegate Capital Limited, who agreed to the appointment in September 2009. George Patelis was appointed Chief Executive of Toyota in April 2010, and he became concerned about the quality of financial reporting at the company. In January 2011, a shortfall of at least £20 million had been identified, suggesting insolvency. He also became aware that Toyota had retained the proceeds when some loans had been redeemed, along with Land Registry DS1 inconsistencies. Mr Patelis appointed BDO to investigate in January 2011, and they confirmed his initial concerns. He then resigned and alerted the FSA to the situation and to report financial irregularities at Toyota. As a result, a case was opened by the FSA and supervisory engagement with Toyota began. The Financial Services Authority required Toyota to engage investigative accountants to monitor its financial performance, and this may well be what my honourable friend for Leicester refers to. And their responsibility was to report to the FSA on a monthly basis. However, instead of undertaking independent investigations, BDO, who had secured the role, relied on information supplied by directors of Toyota. They then produced a series of reports that persuaded the FSA that the firm should be allowed to continue to trade. In May 2011, the FSA issued a consumer alert because of marketing materials indicated the fund was low risk and concerns were guaranteed. the marketing material was amended for IFAs, and Bluegate was made aware of the issues over the security of the loans. In March 2012, Bluegate notified that 1,200 investors notified the 1,200 investors that the fund had been suspended due to an inability to pay quarterly interest payments to investors. Toyota was placed in administration in September 2012. It is suggested that investors face losses of at least 70% of the 106 million that was invested. In addition, they have to date lost up to £20 million in unpaid quarterly distributions. Since then, a number of MPs have written to the FSA and now the FCA and the Treasury to establish the regulatory responsibilities, to investigate the fund and any potential for compensation for investors. Having considered the background, there are a number of points I want to make, along with a few questions towards the Minister. Although I recognise it's an unregulated investment scheme, various elements were regulated, as I mentioned at the outset. The advice process was regulated. I'm not suggesting for a minute that advisors are responsible for the failings and misappropriations of the funds. However, there is a need to clarify where their responsibility ends. In fairness to the IFAs, they will depend on the key financial documents, which weren't accurate or even adhered to. Yet, questions should be asked why unregulated funds were being recommended to investors in the first instance. Clearly, times for such advice for such funds to be advised is very limited. Secondly, what did Capita know in August 2009 when they sought to pass on their responsibilities? What action did they take to ensure proper management of the fund at earlier stages? If they had doubts or questions, why wasn't this communicated to investors? Was their letter to investors misleading, or did they withhold information indicating there were unsecured and unauthorised lendings from the fund? I will give way to my honourable friend.
Is it not incumbent upon the Minister to clarify the legal position for investors on that specific point? Because if investors are to sue for their loss, they need to know the date of the knowledge of the decline of the fund, and secondly, the state of the assets at that time, and to what extent, in reality, the degree to which the FSA are going to assist in the recovery.
Well, okay. I'm grateful to the pertinent point made by my honourable friend. Clearly could be a statute of limitations that affects investors, and that is something that I hope the Minister can offer some advice on. There was obviously a gap between their original letter to investors on the 20th of August, advising of the intentions to pass responsibility to Morant, and the letter on the 24th of September advising that Bluegate would become responsible. Should they have suspended the fund when they realised it was not being managed in accordance with the financial information documents? This is not the first time, as we've already discussed and considered, that they found themselves to be in a position needing to answer questions over their role, and I'm referring to Capita, obviously. And as the authorised corporate director to Arch Crew, they were forced to compensate investors to the tune of £32 million. Now, terms and reasons have still not been disclosed of why that sum was derived and what was their responsibility and what the failings were. But clearly, presenting a sum of this size suggests some form of culpability. Questions should be asked of the actions taken by the FSA, or now the FCA. Some investors believe that they've taken little action. However, the Minister's predecessor advised me in a meeting about, in general terms, of the work that they had undertaken. But this certainly needs to be published to reassure some concerns that some people have, but also to allow further questions to be raised about what could have happened if it didn't happen at that time. I'll give way to the Honourable.
Right. Gentleman, for giving way. Does he believe that the FSA have let investors in Connaught down? And is he also aware of the case of Burgess Salmond, a similar scam which the FSA have washed their hands of and taken no responsibility for? Does he think the FSA needs looking at?
Well, I'm grateful to the Honourable Member for making that point. I'm not familiar with the other case that he talked about, but certainly I think greater transparency on behalf of the FCA would be helpful in this, and it may well dispel any of the criticisms that are being made of them. The fact is, we simply don't know the specific actions they took, if they took any action, at any particular point. Of course, the FSA has now been evolved into the FCA. I hope it's not just an evolution into the FCA. There needs to be a different culture at the FCA to ensure that the failings of the past are quite obviously not repeated. But what about the actions? What about the FCA's actions or the FSA's actions following the intervention from George Patelis? The Financial Services and Markets Act places the FSA, or placed them, on a statutory duty to maintain market confidence, ensure public awareness, reduce financial crime and to protect consumers. I mean, we can also ask questions, what of the police? Surely there are sufficient grounds for the police to investigate these issues because of the misappropriation of funds. Finally, I would ask the Minister if she is able to advise us of any statute of limitations, the point that was made by the Honourable Member Hexam, and whether the statute of limitations falls on investors and ultimately any recourse that could well be available. And Mr Brady, in closing, I want to underline that although this saga has gone on an awfully long time for investors, this is the first opportunity that we have had to discuss this matter here in Parliament. And I'd like to think that this is the start of parliamentary scrutiny over the matter, and certainly not the end of the issue, and I look forward to the Minister's response.
Very good. Well done. Minister.
Thank you, Mr Brady, and it's a great pleasure to be serving under your chairmanship today on my second outing in Westminster Hall. And I'd like to congratulate my honourable friend, the member for Glamorgan, for having organised this debate. It is an incredibly important subject. I also have constituents who've lost a huge amount of money as a result of this very clearly devastating investment that they made. And it is very important that we do get to the bottom of it, that we try to ensure that, if possible, investors can be compensated in some way, and certainly that those who are responsible for it should face the maximum justice that is available. So this is an important issue, not just for his and my constituents, but I see there are a lot of honourable members here in the hall today whose constituents have also suffered as a result of this. So it's very important that the Financial Services Authority, as was, and the Financial Conduct Authority now, take this matter extremely seriously. And I want to reassure him and all other members here today that that is indeed the case. Many of those investors have in fact lost their life savings as a result of the events with the Connaught funds, and this has caused real hardship for people up and down the country. As my honourable friend made clear, the Connaught funds comprise of 3 separate funds: the Connaught Income Fund Series 1, the Series 2 Fund and the Series 3 Fund. In total, these funds had approximately £145 million invested in them. As we know, the funds were unregulated collective investment schemes. By definition, such schemes are not subject to direct regulation by the Financial Conduct Authority or the FSA prior to the FCA. This meant that... Yes, I will give way.
To the Minister for giving way. I visited the FCA with my colleague from the Vale of Glamorgan to look at the issue in question, and we were shown a flowchart which identified the selling process for this investment, and the number of elements which were regulated and the number of elements that were not regulated would imply that there's a significant amount of confusion within the way the regulatory process actually works in the UK at this point in time.
Yeah.
Minister.
Yeah, I think he makes an extremely relevant point. As I was looking into this issue in some detail yesterday, it struck me that exactly the same, that there are elements of regulated bodies and elements that are unregulated, and of course what we've ended up with is a completely disastrous scenario where people have lost a lot of money and it becomes very difficult to get to the bottom of it all. But I'm hoping that if he listens, that we'll go on to try and unravel a bit of that. So, as I say, this means, because of the unregulated nature of some of the entities involved, that many of the usual protections and safeguards which protect investors in regulated funds were absent. That's why such schemes are subject to strict controls over their promotion and distribution. But unfortunately, in this instance, it seems that even those controls did not prevent a large number of individuals investing in the fund. So in addition to the questions that have been raised in the debate, which I'll return to in a moment, there are 2 main issues that I would like to address. Firstly, the actions taken by the FCA to try and protect consumers, despite most of the entities involved being unregulated. And secondly, the work that's currently ongoing for the benefit of consumers and investors in order to secure a fair and proper outcome. So first of all, actions taken by the FCA. Despite the fact that the schemes were unregulated, the FCA has taken a number of steps to try and protect consumers. So I'm just going to run through the timeline. In May 2011, they altered Toyota's permission so it could no longer carry out any new regulated mortgage lending. And they issued an alert to consumers telling them what they should do if they thought they had been missold the fund. In June 2011, the FSA wrote to all financial advisors who sold the fund, asking them to review these sales and to contact consumers where there may be risks of unsuitable advice, and set up a page on FSA's website for consumers and firms to receive information on the fund. And then in August 2011, they required Toyota to instruct Connaught Asset Management Limited to change its marketing materials so they no longer described the fund as low risk and guaranteed, as the FCA took the view that these descriptions were misleading. Finally, in June 2012, the FSA altered Toyota's permission to ensure funds from redeemed loans returned to the Series 1 fund. Yes, I'll give way.
Chris Ray.
The Honourable Lady for giving way. In August of 2012, Capita, the parent government, the parent body of the Connaught Fund, were given a contract by the DWP with hundreds of millions of pounds. Who should pay for the losses? Should it be Capita, or should it be these 1,200 individuals that were falsely sold this investment? And can she use her position with the Secretary of State for DWP to ensure that Capita do the right thing and compensate these individuals?
Well, I'm grateful to the Honourable Member for raising that point, and I will certainly look into the point that he raises, but I can tell him that Capita, those two organisations belong to the same parent, but they are in fact different subsidiaries. And as he may be aware, the awarding of government contracts are made in line with EU procurement rules, but I will look further into the point that he raises. So, as I say, Mr Brady, finally in June 2012, the FSA altered Toyota's permission to ensure funds from redeemed loans returned to the Series 1 fund. In addition to the work by the FCA, I can also confirm that there are other law enforcement agencies looking into this matter, and I will be urging the police to consider this case very carefully. I know members have been interested to know whether the police are looking at it, and I can confirm that they are. The FCA has been working very closely with law enforcement agencies to identify and pursue avenues that will yield the best outcome for investors. In addition, the FCA itself continues looking into this matter, and its work is very much ongoing. In the meantime, they are encouraging any investors who believe they may have been missold a product to contact their independent financial advisor. The FCA has disclosed information to the police and to the administrators of the firms involved in order to help them with their inquiries. So there have been a number of points raised during the debate, which I will now try and address. Capital Financial Managers Limited, was it negligent in its operation of the fund? Have they breached their obligations under FSMA, the operator agreement, or duty of care to consumers? So what I can say is that the government and the FCA take these allegations very seriously, and the FCA is carrying out its own inquiries. But, however, the requirements on the operator of an unregulated fund are limited under FCA rules. Another question, has the FCA made a restitution order against Capita? Well, I would stress that the FCA is considering all the different avenues by which those who have suffered as a result of this matter may be able to obtain compensation. With regards to the information provided by George Patelis, once the information... Yes, I'll give way.
David Davis.
In a number of these cases, some involving Capita and some involving others, it's been very clear that the financial structure of the company has been set up with limited liability subsidiaries in order to prevent the compensation demands going back to the parent. Will she ask the FSA to look at the acceptability of that approach with a view to future concerns like this? Because it seems to me it is a way of a company getting the benefit of its reputation without actually meeting the liability, as it were, that should go with it.
Yes.
Minister.
Yes, I completely agree with him. There are questions to be asked about how this apparent ability to avoid culpability can have been allowed to happen, and whether there are steps that can be taken to ensure that that can't happen again in the future, and indeed whether there are issues of compensation. All of these matters are being looked into by the FCA, but I will certainly take his specific point forward. I was just talking, Mr Brady, about what action the FSA took once they received information from George Patelis. So the FCA met with other parties to discuss the concerns he raised. As a result of those discussions, the financial position of Toyota plc became a serious concern of the FCA. Having considered the regulatory options in respect of Toyota plc, in May 2011, a requirement was added to the permission of the firm that it should cease any further regulated mortgage lending. In the same month, as I've already mentioned, the FCA issued the consumer alert in relation to the fund. A further alert was issued to financial advisors asking them to consider the suitability of advice they had given consumers who had invested in the fund and to take action accordingly. Now, in light of the fact that very little of Toyota plc's business was regulated, the FCA considered these steps to be appropriate and proportionate at the time, and I certainly take on board my honourable friend's point about was that, in fact, in hindsight, acceptable. There are further questions that were raised. Capita issued an information memorandum that consumers believed to be fraudulent, as the fund did not operate as it said it would. So what action is the FCA taking against Capita? So, as I've said earlier, the FCA are currently considering all avenues by which investors might be able to be compensated. But unfortunately, I can't comment on that further at this time. One point I would like to make, because again this question has been implied, which is to say that IFAs are not supposed to sell unregulated investment schemes to retail investors. The circumstances in which unregulated schemes can be promoted to consumers are generally restricted to certain types of consumers, for example, sophisticated investors and high net worth individuals for whom these products are likely to be suitable. So the FCA has recently brought in new rules banning the promotion of unregulated collective investment schemes to ordinary retail consumers. So IFAs do have the responsibility for promoting the fund only to eligible individuals. I think that's a very important point. My honourable friend, the member for Hexham, raised the point about are the police involved, and I can confirm that they are. And another point that was raised is the issue of deadlines for issuing complaints. So the fund was incepted in June-July 2008 and suspended in March 2012. So the causes of action carry a mixture of 6 years from the cause of action, which will start to expire from June 2014. So all those investors who invested in the early days of the fund need to take very careful advice if they are wishing to make a complaint about that product, that the deadline is fast approaching. And or 3 years from the date of knowledge of the cause of action, which is likely to expire in March 2015 or latest September 2015. So I certainly do urge consumers who feel they've been missold to look very carefully at these deadlines. If the case goes to court, it depends on those courses of action. And I can also say that insolvency reviews of those companies will also be reporting in the near future. We don't actually have a date for that other than to say in the near future. So, Mr Chairman, once again, I would like to thank very sincerely my honourable friend, the member for the Vale of Glamorgan, for instigating this debate on what is a very important and very upsetting case for many investors. I hope I've reassured him that the government is fully aware of the concerns he's raised and just how seriously the government takes this issue. We are absolutely determined that our financial services sector serves consumers in the right and fair way, and that investors receive the protections that they need. Thank you.
I suspend the sitting until 2:30 this afternoon.